genitalia in the shower in Florida. Furthermore, acts of insufficient similarity to the crimes at bar, which once again, from the record, the evidence against the defendant was that he committed lewd and lascivious acts by...
You have sexual conduct, sexual assaults, lewd acts upon a child. The legislature has broadened the admission of the evidence, correct?
Absolutely, Your Honor.
And so similarity is but one factor to be considered by the court.
Yes, Your Honor.
The fact that it's the same victim, that would be a legitimate factor for the trial court to consider.
Absolutely. That's one factor of many. Simply because the Florida legislature in 2000 broadened the Williams rule to include any collateral acts that the trial court may deem relevant, still does not open, constitutionally speaking, does not open the floodgates for the government to present...
Constitutionally speaking? What are you speaking of?
I'm speaking of the fact that just because this is a sex prosecution, and two, that there's a
constitutional argument made either below or on appeal?
A constitutional argument made below on appeal, yes. Well, due process undergirds every argument made, and that's what I was talking about. I apologize if I seemed like I was getting above what we argued on appeal, but due process does undergird every argument made by almost every appellant, whether the specific argument would be the trial court abused its discretion by admitting dissimilar fact evidence.
So it's abuse of discretion standard.
Yes.
And what we look at here, isn't it a weighing whether the prejudice outweighs the probative effect?
Yes, that could be also part of it. That's 403. But
right. And so how is it in this case that you claim the prejudice outweighed the probative relevancy of the evidence admitted?
Well, it's highly prejudicial to introduce evidence of uncharged crimes at any criminal trial. And here the defendant appellant was on trial for 5 sexual counts, convicted of 3, all involving manual masturbation of his penis while driving in a truck. Now, it is highly prejudicial, I would submit to your honors, for the jury to go from hearing evidence of the defendant appellant supposedly encouraging a girl to masturbate him in a truck.
Were there some admissions made by your client as to the masturbation counts?
Well, actually, based upon the record that I saw, and this is actually issue 4 on the brief, is the internet transcript chats that were admitted into evidence and then taken in the jury room. I believe that from the record, those are the only admissions, if the only defendant statements made, and I believe that these transcripts were submitted only to the court and not copied for the parties. So me being not the trial attorney, just the appeal attorney, from the record, I don't know exactly what they said, but even if the defendant appellant did make these admissions through the internet chats, the trial attorney objected to the admissibility of the internet chats at trial based upon improper authentication. The trial court commented, and both attorneys commented at trial.
Well, they had a representative from AOL that testified, correct?
Yes. Representative AOL, according to the record, testified that the screen name used in the internet chats was registered to Ernest Wayne SPEER, the appellant. However, there was no direct evidence whatsoever to allege even that the person using Ernest Wayne SPEER's screen name at that time was in fact Ernest Wayne SPEER.
But doesn't that just go to the weight that the jury wants to give the evidence and not its admissibility? That doesn't call into question authenticity. It seems to call into question weight. You can argue, well, that wasn't my client typing those things.
Yes, Your Honor. But it still inherently goes to admissibility or authentication, because if the...
Well, as to authentication, it seems to me that the issue as to these internet chat logs was not that And I didn't see anything to suggest that these were not accurate chat logs. The position argued below was there's no way of determining that it was Mr. SPEER that was sitting at the computer typing those.
I agree, Your Honor.
The one goes to, it seems to me that there was no issue as to its authentication. The issue related to whether or not they were sufficiently, those chat logs were sufficiently tied to Mr. SPEER.
I agree.
Okay, so again, it seems to me that the evidence from AOL that says that this screen name is registered to Mr. SPEER. Mr. SPEER, if you look at the chat logs, and I read them, they seem to suggest a familiarity and things that normally just if I sat down at the computer, I wouldn't know if I exchanged pleasantries with somebody that I wasn't close with. So in that sense, it seems to, again, go to the weight the jury wants to give it, not its admissibility. But I appreciate your argument to the contrary.
Assuming that it was properly admitted, and you've got admissions, at least in terms of the masturbation counts, and he was acquitted of all the other counts, if there were an error in the admission of the similar fact evidence, how would it have been prejudicial or harmful error?
Well, I believe, Your Honor, the harmless error rule is that the admission of the improperly admitted evidence leaves no reasonable doubt. Well, there's no reasonable doubt the improperly admitted evidence contributed to the guilty verdict, and I believe that based on the record and Ms. C.S., that's the alleged victim's testimony in the trial, Ms. Schneep's, or C.S., the alleged victim's credibility was highly at issue in this trial. There was, aside from the internet chats, there was no evidence buttressing her claims whatsoever, such as DNA
You mean
videos.
aside from the defendant's admissions that he...
Aside from the defendant's
that he
screen
committed
names.
the act.
Yes, the defendant's screen names, admissions.
But that's a large hurdle to overcome in terms of a harmless error analysis, don't you think?
No, Your Honor. Actually, no, because the jury can believe or disbelieve anything they would like, and it would be reasonable, or one could see the jury believing that even if these logs were admitted, the credibility of this young lady was so besmirched and damaged that the jury may not have believed her in these allegations and acquitted Mr. SPEER of these three counts.
But the jury did acquit SPEERs of the sexual battery charges.
Exactly, and they could have gone on to acquit Mr. SPEER of the three other counts if it weren't for improperly admitted Williams Rule evidence of a dissimilar nature. And these briefs the appellant submitted cited about 4 or 5 cases where convictions have been overturned on improperly or insufficiently similar Williams Rule evidence in sex prosecutions, including a recent case by this very court of Fike versus State, F-I-K-E versus State 4 Southern 3rd 734, Florida 5th DCA 2009.
Fike involved different victims, though, didn't it?
Yes, it did.
This case has the same victim, the same perpetrator, and basically one course of conduct. Don't you agree with that?
Oh, I have to agree with that, Your Honor. Those are the facts of the case. But what is also the facts of the Fike case is a conviction for sexual activity with those in familiar or custodial authority was overturned based upon insufficient similarity in the crimes charge and the Williams Rule evidence.
Well, one was a male, one was a female. I think the Williams Rule evidence in Fike involved a male victim, whereas the defendant was on trial for the molestation of a female victim, correct?
Correct.
I think another distinction was the location, if you will, of where these molestations occurred, right?
Yes, Your Honor.
Now, in your case, one of the collateral incidents that you're complaining about is the showering and touching incident.
Yes.
didn't that also constitute a part of one of the counts of sexual battery that preceded, that there was a showering incident and a fondling incident that led into one of the counts of sexual battery?
Well, Your Honor, I don't know if I can concede that right now. I don't believe that was argued below. If that incident actually did take place immediately precedent to the alleged sexual battery that the defendant was acquitted of, I don't remember it being argued below with inextricably intertwined or somehow necessary to the telling of the story. In fact, it's not necessary to the telling of the story because
it's my understanding that a showering incident and a fondling incident directly led to a sexual battery allegation. Is that your understanding, or am I based on that?
I don't know if it led to. That may be the distinction I can't draw in my mind, is whether if the shower happened before the sexual battery, which was not guilty on that count, but whether the shower actually led to the alleged sexual battery. But in any case, the jury, after hearing the evidence, decided to acquit Mr. SPEER.
The acquittal, of course, is after the fact, and what we're looking at is at the time that it was entered into evidence, whether it was admissible, whether it had some, we talk about similarity in nature, and it's at that point that we look at, not post-verdict. At the point that it was admitted into evidence, you had one incident where there was a showering episode that led to a sexual battery, and then you've got a separate sexual or showering incident that led to some other conduct. And so why wouldn't that have been similar? It's not inextricably intertwined. They're not, they're temporally separate, but we're not talking about inextricably intertwined. You're talking about similar fact evidence.
Yes, I am. And inherently, activities taking place in the shower where the appellant is actually enjoining a young girl. No, where the appellant is actually touching a young girl and saying he is dirty in the shower inside a house is fundamentally and inherently dissimilar from alleged incidents that happen on the open roads of Brevard County in a truck where the defendant is making no salacious comments whatsoever and enjoining the young girl to touch him. Now, I have 50 seconds left, Your Honors. May I reserve that 50 seconds for rebuttal?
Yes, sir.
Time goes fast, doesn't it, Counsel?
May it please the Court, Counsel, good morning. My name is Kelly Neal, and I'm here on behalf of the state of Florida. First, the Internet chats weren't part of the Williams Rule. They're not challenged on appeal except for the fact that they went back into the jury room. The evidence itself went back there. They're not challenged as far as their admissibility. So I just want to make that clear. There's only the three incidents as far as the Williams Rule notice. There was the incident in Missouri, there was the shower incident, and the ongoing conduct in the truck of the exact same things that happened, they just weren't charged. And as we argued in our brief, I think these are all relevant to show motive, intent, opportunity. The court made very specific factual findings on this, and I don't think the trial court abused its discretion. And even if it did, it would have to be harmless error in this case where, again, the showering incident was part of the capital sexual battery charges. The other charges were proven. He was convicted of those. The jury was twice instructed on the purposes of the Williams Rule evidence. Obviously, they understood the purpose of the Williams Rule evidence because he was acquitted of the sexual battery. So,
talk a little bit about the Missouri instance. I mean, it just seems that it's difficult to really see similarity between what occurred in Missouri and the charged conduct.
The actual act itself is not similar. I mean, he grabbed her buttocks, apparently. But to show his ongoing sexual interest in her, his opportunity to sexually abuse the child. This
isn't an inextricably intertwined analysis. When you start using words like ongoing, I'm not sure what you mean by that.
Williams Rule evidence, as long as it's relevant to motive, opportunity, method of operation, and it was relevant to all those. It doesn't have to be exactly similar.
Anything would be admissible under an ongoing analysis. Whatever he did to her that could be construed as sexual in nature, we know that's not the legal analysis.
Well, it depends on exactly what it was. In some instances, yes, it would be, if it goes to show his intent, his method of operation. I mean, she moved to Missouri, and the first thing he does when he gets back there is tries to have sexual contact with her. So I think it clearly was relevant to his method of operation, his opportunity. Every time he had this little girl alone, in his grandfatherly way, I mean, he had this child convinced that this was normal conduct between grandfathers and granddaughters. And I think it was relevant to show that. And it was relevant to, what's the term? To corroborate her testimony, which under the statute, that is one of the purposes. Under McLean, that's one of the purposes of Williams Rule evidence.
How does her testimony corroborate her own testimony when it's a dissimilar act in a different location, and temporally separated? I mean, if she says the same thing often enough, does that make it true?
No, but when you put the internet chats in there as to things that he admitted, and she's saying, well, when you come back here, please don't do that again like you did last time, something to that effect, then it does go to corroborate her testimony. It did all become relevant. This was one course of conduct, and I think everything that he did to her was relevant in this.
In the situation where you have the same perpetrator and the same victim, is there any limitation with regard to Williams Rule evidence?
Perhaps in some case there could be. I think when you do have that situation, that clearly makes it a lot more relevant. I mean, in this case, the state could have charged other incidents. We couldn't charge the Missouri ones because clearly we didn't have jurisdiction to do that. Interestingly, he did plead to the Missouri charges. So, yes, I think in terms of his conduct towards her, and in a case where there is ongoing conduct, that's usually what the courts find. I mean, I believe it's the Padgett case out of this court where the court found it's the same victim, and pretty much everything that he did to this victim was admissible to show his intent, his opportunity, his method of operation, his sexual attitude toward the victim. And again, if the only incident that the court is troubled about is the Missouri incident, I mean, that was just such a minuscule part of the evidence in this case, I think it would have to be found to be harmless error. If there's no further questions, I would ask this court to affirm the convictions and sentences. Thank you.
Thank you. Counsel?
May it please the court, I just want to make sure that I don't waive any arguments that I set forth in the initial brief and the reply brief. I'd like to briefly address the issue of sentencing. Mr. SPEER is asking in the alternative if the conviction is affirmed, at least maybe the court could reverse the sentence based upon.
But why can't remorse be considered as it relates to the request for mitigation?
Because
as opposed to the consideration of a lack of remorse in terms of increasing the sentence.
Because the comment and the argument was made by the attorney, the trial attorney, not the defendant himself, and any comments made by an attorney are not evidence, strictly argument.
My question is conceptually, why couldn't an individual's lack of remorse be a legitimate factor to consider when viewing a request for a downward departure for mitigation?
No, conceptually.
Do you have any case law that says that can't be considered for purposes of the mitigation?
Well, I don't believe there is any case law on the subject. However, conceptually speaking, that may jeopardize an attorney's sworn duty to vigorously vigorously get the best results for his client. If an attorney himself would be...
But we're sentencing now. The defendant is free to elocute and have elocution in terms of sentencing. So we're talking about whether it would be a legitimate factor to be considered by the court when someone asks for mitigation or mercy.
Well, I don't believe it would be, Your Honors. I don't believe there's no case law on the subject. But if a defendant asking for mercy, but a defendant saying, I know I've been convicted, I'm going to ask for mercy, if that statement could therefore be used against him as sentencing to increase his sentence,
you're not increasing a sentence. You're simply not reducing a sentence.
Counsel, you've exhausted your time. Thank you so much.